Did you know that Ontario's rental landscape just shifted? The Landlord and Tenant Board is rolling out the biggest set of changes to the Residential Tenancies Act in years. And whether you are a tenant or a landlord, these new rules affect you. So why does this matter? Here's the law. Let's break down exactly what is new. Note, some changes took effect July 1st, 2026. More are coming this September. So first, the appeal window just got slashed in half. Previously, you had 30 days to request an internal review of an LTB order. That deadline is now 15 days from the date the order was issued. If you missed it, you will need to apply for an extension and explain why. And here's the kicker. Reviews are no longer a routine chance. The LTB will only grant them for genuine procedural issues, significant errors, or exceptional circumstances. For landlords, fewer delays on successful eviction orders. For tenants, act fast if you're challenging a decision. Second, handshake agreements are out. Mandatory forms are in. Landlords and tenants can no longer use informal written notes or verbal promises for rent arrears repayment plans. Any repayment agreement under Section 206 of the RTA must now use the official LTB Payment Agreement Form. This creates a clear, consistent record. No more misunderstanding about who promised what. Third, your right to cool air just became law. Tenants now have a legal right to install their own window or portable air conditioning units. But there are conditions. You must give your landlord written notice before installing, including details about the unit's energy efficiency. If utilities are included in your rent, landlords are legally permitted to charge a seasonal rent increase to cover the electricity costs. The charge can't exceed actual or reasonable estimated cost, and it must come off when the unit isn't in use after summer. The good news, the seasonal increases does not follow normal rent increase rules. No 90-day notice, no 12 months wait, no LTB approval required. Fourth, fines just doubled. Seriously. Maximum fines for major RTA offenses, think illegal lockouts or bad faith evictions, have doubled. Individuals now face up to $100,000 in fines, and corporations up to $500,000, that's $500,000 in fines. The message is clear. The province is serious about compliance. Fifth, document deadlines are tightening. For above-guideline increase applications, the direction to serve timeline drops from 14 days to 7 days from the date of issuance. And landlords now have just 5 days to file a certificate of service with the LTB. Miss these deadlines and you could lose your AGI application entirely. What does this mean for you? The reforms aim to reduce delays, improve consistency, and strengthen compliance across the rental housing sector. But here's what you need to remember. The timeline to challenge an eviction order has been cut from 30 days to 15 days. If you're a tenant facing eviction, don't assume you have time to figure it all out later. You have only 2 weeks, not a month. That said, tenants still have rights. You can challenge eviction notices if you believe they are in bad faith. If you're a survivor of intimate partner violence, a recent landmark ruling safeguards your right to remain housed. So, here's your move. If you're a tenant, know your rights. Don't move out without a hearing. Understand that the new 15-day review window and act within it. If you're a landlord, understand the new timelines. Use the mandatory payment agreement form. And remember, missing a deadline can cost you literally. The law has changed. Know it, use it, protect yourself. Now you know.